to the April edition of Bootlaw. For those that don't know us, I'm Barry Rittu. I'm a corporate technology partner here at Winston. This is Dan, who works with me in this field. And tonight the crowdsourced topic, with loads of questions, is employment law. We have basically pulled all the questions. We've tried to answer as many as we can during the course of the talk. We are aware this is a popular topic, so if there is an appropriate moment during the course of us speaking, then please feel free to ask questions. And we will answer questions in the usual way after we've done our sort of turn. This isn't, well, what this isn't though, it is not a get the boot law, right? This is a startup environment, so we're not talking about sacking people tonight. Although there's plenty of it going on. This sector is basically supposed to be digging us all out of recession. And we're obviously in capable hands looking around. Well, actually, before I do that, some housekeeping. Usual way. We will have a champagne bucket somewhere for some business cards for the iPod that I haven't dug out yet to give away for the lucky winner. No notes. No need to take any notes because we will post up our speaking notes onto the site at some point after this evening. Hello?
And there's a video.
And there's a flip video on our very own YouTube Bootlaw channel. I don't know if we've got that, but anyway. To kick off though, just taking a step back, you want to do a startup. I know that some of you in the room have already done it, but some may be sort of fantasising about the next Google from their, from their shiny office of their current employer. So some do's and don'ts if you're in that situation, and actually it's sort of mostly don'ts to be honest. Moonlighting, and it's not the sort of cheesy rom-com detective programme with Bruce Willis and Sybil Shepherd. Moonlighting at work is basically a bad idea. Okay, so there are a few reasons for that. First, if you spend every waking hour in the office while you're in the employment of somebody else setting up your startup, you will probably get the sack. Second, also if you do that, there's a strong argument that what you are generating actually belongs to your current employer. So there was a case a couple of years ago where somebody, it turned out he was a journalist, rolled up at his new employer and downloaded his contacts list into Outlook, which basically everybody does. And he obviously augmented that over a couple of years, and then he left. And I think it may be relevant that he went off to a competing business. But there was a big, needless to say, there was a big bust-up. And the court held that the contacts basically belonged to his employer. Now, I'm sure there was an element of bad behaviour there, but it's definitely worth bearing in mind. And the other thing to bear in mind is that, and again, it's very broadly speaking, the boot law from 40,000 feet view, but IPR that you create under the Copyright Designs and Patents Act, 88, and the Patents Act 77, will generally speaking, if created during the course of your employment, which will definitely equate to if you are at work, belong to your employer. So you don't want to be creating too much when you're there. And then the big question is, what does during the course of your employment actually turn out to mean? And that is a really big question that frankly you don't want to have to answer. So the key thing is to try and be a bit sensible and clever about what you do. So invest a few £100 in your own computer so you're not downloading it onto your employer's computer, and do it in your spare time, and keep what you do generate to an absolute minimum. I mean, obviously there is some, we've all got to be practical about it. I mean, I am aware of people that have done startups that have actually approached their employer in time before they, while they've been in the employ, and they've had their tacit, if not written, sort of buy-in to what it is that they're doing, and that sort of gets rid of the issue. But that obviously won't be appropriate in every case. But just be proportionate and be reasonable is what I would say. Actually, one other thing I will mention is that in addition to the basic law which we've just talked about, also you should all read your employment contract with some care. And that's because some of them go completely over the top. So we've had instances, well there are clauses out there designed to get you that say any IPR that you create belongs to your employer. So we've actually, we have received a letter here where another big law firm claimed that a domain name bought by, I think, somebody's wife, while they were an employee, setting up for their startup, which they hadn't got going, what belonged to them. It was obviously rubbish because it's not IPR for a start, and two, you might think, and I would agree, that if you write your letter to Father Christmas, clearly they don't know the copyright in that either. But the point is, they try it on, and you end up with a very lengthy letter from a fancy law firm that you've got to deal with, because you don't want that piece of paper and all that correspondence sat in your file. So when anybody comes along to invest in you, or whatever it is that they might do, buy you, whatever it is, come along and say, well, what's all this? Who does own this IPR? You've got various people asserting claims over it. And it costs, money that you really don't need to waste to deal with that correspondence and get shot at the problem. And then actually one final thing I'll talk about is confidential information. And the simple answer is don't go there. Because if basically you steal, which is what it is, confidential information, you won't have a leg to stand on, it's going to cost you a lot of money with lawyers and a load of aggravation and grief that you don't need. So with those, they're all the don'ts, but people do startups all the time. So it's just, I would emphasise, just be sensible about it. Use a bit of common sense and you won't have any issues. So that's sort of pre-startup. Now let's assume you've started up. What happens next? And another question that we had was, do we need to use employment contracts? Do I need an employment contract? And there's a really easy answer to that from a legal perspective, and that is yes, because as a matter of law, you are supposed to have what lawyers call a Section 1 statement, which is basically a series of terms which include things like who your employer is and the address and all that sort of stuff. I mean, if you were to, and I know lots of people don't do this, but if you were to comply with that, you might as well go the extra mile or the extra, couple of centimetres and create your employment contract. Okay, but there's a sort of an element of practical advice here. I mean, obviously, we can do all this stuff for you, but frankly, it's pretty inefficient for us to be writing people's employment contracts, particularly for sort of developers and stuff like that. So I wouldn't. What I would advocate is that if you're a startup, money well spent is a few quid on a subscription service for an employment law site. Because you'll get a whole bunch of precedents. They'll do the job that you need at an early stage. You'll be able to get some very basic employment law advice, which will be useful, and you can pretty much forget about it. And it will get you where you need to be at that period, for that period of time. Obviously, if something really tricky comes along and you get the nasty letter in from some fancy law firm, then by all means come along to us, and we are well versed in getting people out of trouble. But I mean, but in terms of sort of a basic employment contract, it really isn't worth it.